Gwilym, we're back in a pub, mate. How's that? How's that feel?
It feels good. It feels British.
British?
Yes, this is how the country should be run.
Oh, we probably don't want to go down the road of how the country's being run at the moment, do we?
It actually feels like it's being run from a pub anyway, doesn't it? Think about it.
I'm really disappointed we couldn't get Gary Lineker on the podcast. That would have been...
No, he's on. We can't say things now, can he?
No, he's not allowed to speak in public anymore, is he, at all?
No.
Anywhere.
How are you?
No, I'm fine. I'm all right. Yeah.
Do you know what we haven't done for ages?
Go on.
The tortoise.
He's still asleep, mate. He's still in the fridge.
No, that's probably why.
But it is... we're just about edging towards that stage where it's wake-up time.
Right.
And so that means getting him out of the fridge. So he lives in the fridge in a plastic box full of soil. He's a bit like a vampire. He likes to sleep on his own kind of...
that makes you his familiar.
Yeah, I'm absolutely the tortoise's familiar. So I dig a little bit of soil each year out of his house and put it in a box, and then he goes in the box, and then he goes in the fridge at about 5 degrees, which is absolutely perfect for 3 months.
Yeah.
And you get him out, but you need to bring him back to temperature slowly. It's like a good pie. You don't want to you don't want to overheat it. So he'll come out. He'll live in the conservatory for about a month where he can warm up gradually, and then he'll be back in the garden. And this year, so exciting, of course, because we bought a dog. Back to you do know that?
Dog name?
Indy.
As in Indiana Jones.
As in indigo, because he's blue.
Oh, not half as interesting.
So
Hang on, it's blue.
Yeah, blue.
It's a Smurf dog.
Blue Whippet. No,
Well, not actually blue. I mean, like bright blue.
No, it's I've been looking up actually. It's a genetic disorder in whippets.
It is.
Yeah, that,
bright blue
that causes black fur to have a blue sheen.
Oh, that's quite nice.
And it is quite cool. So we'll be introducing the two of them to one another. That'll be fun. See how that goes on. Last time we had a dog, the tortoise absolutely terrorised it.
That's okay. That's a surprising turn.
No. They are tortoise. Is that the plural? Tortoises are quite vicious when it comes to protecting their estate.
All right. So if Indy tries to get in the fridge, he'll have his head chopped by a tortoise,
or anywhere in the house where the tortoise goes, which is anywhere in the house, as you know.
Hang on. Wait, no, okay. We need to get onto the potty. How does your tortoise get up the stairs?
He just got upstairs. Obviously, that's stupid. He's not a Dalek.
Lee Davis and Gwilym Roberts are the two IPs in a pod, and you are listening to a podcast on intellectual property, brought to you by the Chartered Institute of Patent Attorneys.
Gwilym, we're going to do a podcast, mate, and we've got a guest. It's a bit rude because we're sat in a pub and we've not introduced him yet. Donal O'Connell. Donal, welcome to the podcast. How are you, sir?
Thank you very much. I was wondering where that conversation was going with the...
Nowhere. Absolutely
Thank you
nowhere.
very much
A bit
for
like a
having me
tortoise
here.
in front of some stairs.
We never know where the conversation's going, but apparently our listeners, both of them, quite like the...
What, Indian Albert Treacle?
Yeah. they quite like the tortoise banter. It was a big thing over lockdown, the progress of the tortoise. Yeah. So, tell us a bit about yourself. Who are you? What do you do? That sort of stuff.
So, my background is an engineer. So I'm not an attorney. Software engineer, hacker back in the days of Atari and Philips. Joined Nokia and went up the traditional engineering career ladder and really hadn't given much thought to IP.
Right.
I suppose my first interaction with IP was as an inventor, so I ended up with some patents to my name, but really didn't think much about the fact that I was being quizzed by a patent attorney about something I was working on, and ended up with a nice plaque on the wall, and that was about it.
That's all they do. That's all they do, yeah.
I was asked to set up a greenfield site in Texas, so I moved to Texas for many years and made the mistake of, we had some empty offices and the IP department at Nokia was growing, and I said, fine, you can occupy those offices, thinking that was about it. But of course we were in Texas, and the Eastern District of Texas is quite a fun area to be. And I suppose being the senior technical guy, I kept getting dragged across into IP projects. Everything from just helping the IP people navigate the R&D environment, to giving depositions, and quite liked the interaction with the IP folks. And then I was moved sideways to become director of IP at Nokia. So it was like being given a blank sheet of paper and told, go figure out what is best in class with an in-house IP department. But this is now when Nokia was a 800-pound gorilla with 120,000 employees and an IP department of a few hundred. And we were trying to figure out how do you run a well-oiled IP function. Everything from the interface with the inventor community, how you communicate with management, how you manage your external network of IP firms, what tools you use. So for 7 years I had fun basically running an in-house IP department. We did a lot of benchmarking, made a lot of change projects, and it was an interesting experience. 2009, I decided to jump ship family reasons. My son had been ill, and I set up my own company, thinking I would do a one-man consultancy. So I would help other companies do the same type of change projects as I'd done in
That you did at Nokia, yeah.
Over time, we actually transitioned to being more a legal tech company. So we hired some software people, and we started developing IP tools. Our focus tends to be on white space. So we're not going to be the company that develops a patent analytics tool. There are much better companies out there. Yeah. We're not going to develop a patent data management system. So we look for white spaces where there's nobody operating, and we think, hang on, there's a way of automating that.
Yeah.
In 2014, I had a bit of a road to Damascus moment with regard to trade secrets. Now, I must admit, up until that point, if you'd asked me about trade secrets, I was thinking, well, why would anyone pay attention to trade secrets?
Well, it's a good job we didn't have you on then, wasn't it?
It was, trade secrets were ignored, to be honest. They would be way down the pecking order. Patents or trademarks would be the dominant form. But a couple of things happened very close together. First of all, one of the big four advisory companies asked us if we were developing any trade secret solutions, which was an interesting question to get asked as to why are they asking for a trade secret solution. We had other software already developed.
Yeah.
That prompted me then to look around to discover that one of my friends in the US, who I didn't know that he was involved in it, was actually crafting the US Defend Trade Secrets Act, which is the major federal trade secret law in the US.
Yeah.
And when I spoke to him, he said, no, watch this space. There's some interesting developments, and it's going to pass. It's got support of Republicans and Democrats, so we're going to have strong federal trade secret law. He then said, well, aren't you keeping an eye on what the Europeans are doing? And I said, what are they doing? And he said, well, there's the European directive coming. And that then forced me to go explore, to discover that one of the guys that I knew in Ireland was on the task force writing the European directive. And as a result of further investigation, I came across some people who were working for various government departments in EU member states who were tasked with enacting it once it had passed. So it prompted us to think, hang on, something is stirring in this area. And we decided, okay, we're going to start paying. We started the Skunks Works project, first of all, which was what we normally do. And then we started developing trade secret tools. I remember the conversation with my software guy, lead software guy. I said, I need a trade secret tool. And he said, well, what do you want it to do? I said, well, I want it to manage trade secrets.
I can't tell you.
And I said, he said, well, what's that mean? So we were thinking, so what we first of all did was we looked at patent systems and said, well, should a trade secret management system mimic a patent system? And realized very quickly, well, no, they're very different forms of IP. There's no interaction with the patent office. There's no dates. There's no office actions.
Yeah.
That's the wrong place. And we ended up actually looking at library cataloging systems as our inspiration, thinking, well,
it's just information.
It's just information, and there are different forms of information, and they're like a librarian having to understand, well, I've got a book over there that's a children's drawing book, and over here I've got War and Peace, and over here I've got a romantic novel, and you've got to figure out, okay, how do I manage the assets in the library? And in many ways it's like how you manage the assets in a company. So that was our sort of journey into trade secrets, and it's proven a very interesting area for us because clearly trade secrets have grown in importance.
So we've got quite a wide listenership. There'll be attorneys listening to this, there'll be trainees listening to this, but we also get people who are just interested in IP and invention and so on. Do you think you could help people listening to understand what is a trade secret in its simplest form? What is it?
Well, the definition is quite simple. It is business information that meets three criteria. It must be secret, it must have value, and you must have taken reasonable steps to protect it.
Gotcha.
So you'd say, okay, well, that's it. You now know about trade secrets. But if you delve a little bit deeper, obviously, it means that the information can't be in the public domain. If I can do a Google search, if I can read the Sunday Times and I see the information, then it's not a trade secret.
Yeah.
You must keep it secret. So it's a bit of a fragile asset. In other words, you can't have a trade secret on Monday, decide to publish it on a Tuesday, and then change your mind on a Wednesday and say, I don't know, I want to put the genie back in the bottle. Once it's gone, it's gone.
Can I ask you actually on that third one? That's really interesting. That you've got to take reasonable steps to protect it.
Yeah.
Because I would have inherently said, if it's a secret, it's a secret. But this definition has an extra one, which is that you have to actually be treating it as a secret.
Yeah.
So even if no one knows it, if you don't care that no one knows it, it stops it meeting the definition of a trade secret.
Correct. If you take no reasonable steps, then you don't have a trade secret. Now, the challenge is the law in most jurisdictions doesn't actually go beyond the phrase, you must take reasonable protection. Yeah. Of course, what's reasonable to you may not be reasonable to me. Mm-hmm. So what we're saying is, Like, for example, in Germany, when they enacted the European directive, they went further. They felt, hang on, reasonable protection, we need to clarify that. So they talk about, in a sense, layers of protection, like the layers of an onion. They talk about, we expect you to take administrative steps, legal steps, and technical measures. So an administrative step would be, do you have a trade secret policy in your company?
Yeah.
Do you educate your employees?
So employment contracts,
employment
clauses, stuff like that.
When you hire new employees, do you remind them of their requirements not to bring a trade secret from your previous employer in and contaminate us?
Yeah.
So they'd be administrative steps. Legal steps will obviously be things like your employment contracts. Do you have trade secret provisions or confidentiality provisions in the agreement? Your subcontractor agreement, your agreement with suppliers and so forth.
Yeah.
And then technical could be everything from, do you lock it in a safe? Although most trade secrets are probably digital these days. So on your network or on your computer systems, do you have access control? Do you have cybersecurity? Do you have encryption? Now, obviously, it's not asking you to turn your company into Fort Knox. You must take reasonable steps.
Yeah.
So if you're involved in a dispute later on, you need to be able to articulate what steps you took. And there have been cases where of trade secret disputes where the plaintiff has not been able to articulate anything, and the case has been dismissed. They said, well, yeah, you might think it's a trade secret, but you've done nothing to sort of protect this information over any general information in your company. Like the example I give sometimes is, we've got a menu here in front of us. So imagine your company has a canteen menu, and the menu's on a file on your computer system so every employee can see what's on the menu today. What steps did you take to protect the trade secret over and above your menu? And if the answer is, actually, I treat them both the same, then you've got a problem. So you should be able to articulate what steps. But clearly, it's on a case-by-case basis. So you're not expecting a 4-person startup probably to have the same steps as a large multinational.
Yeah.
But you must take reasonable steps. And that can be a challenge because some companies don't think about it like that.
So one more kind of legal kind of
Go for it, mate.
structural question, and I know you've got lots of practicalities, which is those 3 steps. Is that a fairly common definition of trade secrets amongst statutes around the world?
Yeah. In fact, so likely in a number of jurisdictions in recent years. So we take sort of sequence. Japan in January 2016 changed their trade secret laws. Mm-hmm. US brought out federal law in May 2016. European directive was June 2016 and enacted 2 years later, June 2018, because member states have 2 years to enact it. So, for example, European directive is trade secret law here in the UK, and it still is on the books whether we get rid of
until the REU out.
Yeah.
And China has a series of trade secret laws, but their main one is the anti-unfair competition law, and that's been updated 2018 and 2019. But one thing that's interesting about all the law changes is this sort of harmonization towards a common definition. And it's these 3 points. It's secret. Like, for example, what's interesting as well is to look at what's not indeed there. So there's no requirement your trade secret is technical.
Yeah.
Even though some people, I hear people using the phrase hard trade secrets and soft trade secrets to distinguish between technical and non-technical. The law doesn't say anything about that. So you could have a trade secret which is your client list, your some financial information, marketing plans.
So business sensitive stuff.
But valuable.
Yeah. So obviously you'll have technical trade secrets and you'll have non-technical trade secrets, but as far as the law is concerned, it doesn't distinguish between the two. Whereas obviously that's a big difference between obviously trade secrets and let's say patents, which obviously have to be technical. There's no requirements, for example, that the information is static. So we think of like a patent. Okay, you're tweaking it and so forth, but you come to a point where it's frozen in stone. Yeah. But you can have a trade secret, for example, which is your software code. And your software engineers are working on it. They're fixing bugs or adding features. So your code is slightly different yesterday, today, and tomorrow because you've tweaked something. Or you have a data set and your sensors are taking readings and your data set is slightly different yesterday, today, and tomorrow.
Yeah.
There's nothing wrong with that being treated as a trade secret, even though it's changing. Mm-hmm. What is also interesting is, apart from a few jurisdictions, there's no requirement about marking it. So it doesn't say you've got to put a trade secret stamp on the front cover. Now, there are jurisdictions that do require.
Oh, so you mean the spy things we see where they carry it around with top secret?
Top secret,
that's not.
The law doesn't say anything about marking. However, what's interesting is whether, forget the law, does common sense say you should be doing it? Now, I've come across companies who are saying...
Let's turn to common sense. That's a sound like.
Well, just because the law doesn't say you have to do it, should you do it? And I see different arguments. Now, I'm in the camp that says you should at least consider it. And you should consider it for certain subset of your trade secrets. Obviously, because of things like open collaboration or collaborative innovation, R&D subcontracting, subcontract manufacturing, more and more trade secrets are being shared. So I'm in the camp that says if you're going to share your trade secrets, there's an advantage of putting a stamp on it. Because then the other party, it's hard for them to deny that they're giving a trade secret. Clear and obvious.
Yeah.
And the reverse, if someone entrusts their trade secrets with you, it might be good practice to say, well, before you give it to me, stamp it, so that I know that it's a trade secret of yours. And we know that that's a problem because if you look at the trade secret litigation, a large number of the cases involve former friends. Two companies that were collaborating and then they fell out. I mean, just recently, Ford, I think, got fined $105 million for trade secret theft. But if you look at the party across the table, it was a supplier of theirs since 1998. So they've been working with this company for 15 years.
Yeah.
And they had a falling out. And they were then accused of stealing a trade secret that was legally belonging to the other party. And they had abused it and shared it with somebody else or whatever. I can't remember the details. Yeah, what's not in the law, I think, is also interesting. The marking, the documentation. The law doesn't say anything about how you should document your trade secret. So it's not like a patent where there's strict rules about how you lay it out, the claim charts, the drawings, the page numbers.
Yeah.
And of course, it's obvious as well because the way you would document software code would not be the same way as you document client list or marketing information. But again, common sense would say you don't want your trade secret in the back of a cigarette packet. You don't want to be going to court saying this is the most valuable asset we have, and then you crunch out this cigarette packet that's been in your pocket and you're saying, there's my trade secret, it's really valuable. They go, again, that doesn't look like a valuable piece of information. So you should document it professionally. But the law doesn't say anything about how you document your trade secrets. It doesn't say it has to be a PDF or it has to be a .doc or .matlab format, nothing. And of course, that's obvious then when you look at it, saying, well, they can't define it because the way you would document marketing information would not be the same way as you document software code. So there's a lot of flexibility built into the law.
It has to be.
It has to be. But it does then, I suppose, pose a challenge for companies who begin to think about, okay, what should we be doing? And expecting to get clear guidance, and often you don't get that.
So take us back when we started to talk about how you got into this area, and you talked about leaving Nokia and setting up a consultancy, and that was to help other companies go down the same sort of journey. How do you identify that you've got something that would be best protected as a trade secret and not through any other form of IP? How do you? That's the thing that I'm going to lock in a safe. That's the thing that I'm going to hide away.
Well, first of all, if it's easily obtainable by third parties, then forget trade secrets. I mean, if you had, for example, the user interface of your software code and your software is going to be out in the marketplace, I'm thinking, well, trade secrets doesn't even apply here because the minute I look at your code, I'll see the user interface and it's going to be widely available. And so you've got to first of all think, how easy is it to keep it secret? And certain things will lend themselves to trade secrets. So, for example, if you have a lot of stuff hidden away in the cloud, so for example, the Google search algorithm, that piece of code, well, what are the pros and cons of trade secrets versus other forms of IP? Well, if you patent it 18 months from now, I'll know what you've patented in that algorithm. So you've got to look at, first of all, how easy is it to the secrecy aspect to keep it maintained?
Yeah.
The second thing is it valuable? If it's not valuable, forget it. And then, of course, that then triggers, if you pass the secrecy and the valuation checks, then it's, okay, can I take reasonable steps to protect it? I think the issue we're seeing with companies is a lot of the companies that we deal with, they're just starting their journey. So they're thinking, okay, well, there's now these strong laws in place, I'd be a fool not to avail of it. And there's two things you've got to think about then. First of all, what basic foundations do I have to put in place so that I actually can manage trade secrets? So do I have employee education? Do I have policies? Do I have governance? Do I have metrics? And then, of course, you come to your assets. Well, what are my trade secrets? And how do I go and identify them and so forth? And in a sense, you've got to crawl to your organization because many companies haven't looked or they don't maintain a register.
Is it easier when you're smaller? Is it something that becomes more difficult as you scale up?
Well, there's a large European multinational we know quite well. And they're one of the few companies I know who have a full-time trade secret manager.
Right.
And he's been in the job for about 2 years. And apart from things like policies and training, one of his remits is to crawl through the organization. Now, this company has facilities in multiple locations. So he's got like a plan that runs for a number of years. And the first thing is like, for example, he goes to a factory in a particular country, meets the factory manager and says, okay, I believe or I suspect that there are probably trade secrets in your facility. We've got to go figure out what you have. So it's it's a very manual process in that regard, because I suppose one thing that's interesting about trade secrets is you don't have an 800-pound gorilla like the patent office holding your hand. You're on your own. With the patent office, with the patents, you in a sense are given the process. You can, for example, decide, well, I'll prosecute before I draft the patent application. No, that doesn't work. You're told you've got to draft, you've got to get your inventions, you've got to analyse them, you've got to make a decision, you've got to draft it, file it, prosecute. That's the process. But with trade secrets, you've got to figure out what's going to be my internal process for identifying these assets, deciding is trade secrets the right way or not, and if it is, then have I got the right things in place?
So let's take that a wee bit further. Sorry, Gwilym, I'll let you speak at some point. Don't worry.
Keep going. I'm going to get some chips.
You go get some food, and I'll
bring them over.
Audience humour, laughter. Yeah. So this is quite interesting because again, take the patent example. When it gets infringed, you know what you need to do.
Yep.
There's a kind of well-trodden path that we go down. So two things, I think. You've taken all of the steps that you've brilliantly described to protect your secret. How can you monitor that compliance? How do you make sure that it's not exposed? And if you do find that is a leak the right word? I don't know what the right word is.
Well,
I wanted to use infringement, but that doesn't feel like the right word.
No,
so if it gets out, what can you do?
Okay, well, trade secret law only protects you against theft. Doesn't protect you against independent creation. Doesn't protect you against reverse engineering.
Yeah, so it needs to be your secret that's stolen. Yeah.
So imagine you're now in court. And so the plaintiff has to prove three things. I've got to first of all prove that the information that was stolen is actually a trade secret at the time of the incident. And we're seeing examples of court cases where the court case has taken place 5-6 years after the incident. So I've got to prove that 5 or 6 years ago, I was treating that information as a trade secret.
Yeah.
I can't just go to court and say, trust me, Your Honour, of course it was a trade secret. You get laughed at. So what evidence do you have that information was being treated as a trade secret? That it had value back then, you had reasonable steps, you had limited access, you were doing the right things. And that can be a challenge if you haven't been maintaining a register of what you have. Secondly, I've got to prove that you stole it. Not anybody else, that you stole the trade secret.
Yeah.
So I've got, again, it may be through IT forensics, it may be through a camera watching what you were doing at whatever, it could be whatever, but I've got to be able to prove that you stole it. And thirdly, I've got to prove that there was damage to my company as a result of the theft.
Okay, yeah.
Now, all you have to do is prove one of those is not true.
Yeah.
Now, you could argue that there's an initial step before those three steps, which is called reasonable particularity, is the court has got to all agree what it is that we're actually fighting about. What's, in essence, the trade secret? It's that client list that we're talking about. Okay, now we're clear. So there's a sort of clarification about what is the information that's in dispute. And then, yes, it was a trade secret at the time of the incident. Yes, you stole it. And yes, there was damage. And then, of course, the thing that's interesting at the moment is that we're seeing quite dramatic penalties being awarded. This is criminal law.
I was going to say this is more criminal than civil, isn't it?
Well, in certain jurisdictions, European directive is a civil issue, but the European federal law in the US is. There are people, as we're having our fun here with our Cokes and beers and our chips, there are people in prison for trade secret theft.
Yeah.
That's how serious it is.
I should have listened to this podcast, that's what I'm going to say.
You think about it, there's a...
Can you say it without crisps in your mouth next time?
There's a scientist in Ohio State as prison at the moment for trade secret theft. Now, I don't know what the pecking order in prisons are, but I think mass murderer, serial killer, or terrorist is way up higher than the trade secret theft.
You would think,
but he's in prison.
Yeah. You said, sorry, I'll let you come after this one, mate. After this one, and I know you just used an arbitrary time there. It was like 6 or 7 years ago. Are there any time limits or other restrictions in relation to a trade secret? So can you go back 20 years and say...
No, I think I'm not sure about the different jurisdictions. I think the European directive has 6 years.
Right.
Yeah.
So that's why you... Yeah.
But we're seeing... Yeah, there's a US case. The incident happened in 2011. The dispute started in 2013. I think it went to court around 2018. That's the other thing that's interesting as well. Many of the jurisdictions have extraterritorial aspects to their law, so it doesn't actually have to happen in the country.
Right.
The US trade secret law, as long as there's some US link, And we're seeing a lot of non-US companies getting themselves into difficulty and suddenly shocked that they're being dragged into a federal court case. And they're thinking, well, I'm not even in the US. But yeah, no, it doesn't matter. So Japan, I think the Chinese law, they all have extraterritorial. So as long as there's a link to their country, they can come after you.
Go on, mate. Sorry,
So my
I've just sorry.
I've just followed my baba ganoush on toast as well. Which is just like, so going back to the director of the federal law, that's overlaid onto the contractual obligations of somebody. So somebody's working for you, they sign all kinds of contracts and everything, but they won't steal your stuff. If they do, not only can you go for them through the contract route, you've got something over on you. So if the clauses weren't quite in place contractually, you can still get them.
And we've seen examples of, I mean, we're aware of a case going on at the moment, and we're liaising with the litigation firm. And it's interesting to hear their thinking is that they're looking at, well, do we use trade secret law in this case, or do we go after them for an employment contract, or even do we use non-compete? In the US, that's still quite strong. So that's one of the issues actually as well with trying to find records of just how many trade secret disputes are taking place, because unlike, for example, with patent disputes, the coding of the case, particularly in the US, isn't as good with trade secrets. So you might say, well, that's an employment contract, but it's actually a trade secret that was prompted it, or it could be a dispute about an agreement between two companies, and you say, well, it's a contract dispute, and you say, oh, no, it's really a trade secret issue, but it hasn't just been codified like that because they determined that the best way to resolve it was... So the other thing I should highlight as well is that I think that companies who decide to take trade secrets seriously have to think about the language they use. Oftentimes, we use the words trade secrets and confidential information and know-how as if it's the same thing.
Yeah.
But I'm in the camp that actually you should be careful with the language. So I see them all different. They're very similar, but there are differences between the three. So trade secrets are confidential information. But not all confidential information is a trade secret. So I see...
Right.
So for example, let's say you've got a company has a bank account.
Yeah.
And let's say the financial director is also given a card that he can use the ATM machine.
Yeah.
And he's given a 4-digit PIN number. Now, obviously, that 4-digit PIN number is important information, but I would see that as confidential information.
Yeah.
There's no way that's a trade secret because it doesn't give you an edge over any other company because a lot of other companies have bank accounts and they have PIN numbers. Yeah. So there's stuff that is confidential. So I think the difference is I don't see if the value characteristic isn't there. So obviously, confidential information is secret and trade secrets are secret. But I think some confidential information really has no value. And I think that people need to understand that it's not the same thing. But I see companies using the terms. And then know-how is undocumented. It's in the employees' heads. Now, I don't know what's inside in your employees' heads, but some of that stuff is of absolutely no value. It's know-how.
That's most of my staff.
Yeah, so so for example, I kid myself that I'm good at gardening. I like to potter around my garden at weekends. And I know how to grow roses. So that's know-how I have. But if I tell my neighbour that know-how or advise her about how to grow the roses, or I publish an article in the Sunday Times, I still have the know-how.
Yeah.
But so does half the UK now.
Yeah.
You can actually have know-how that actually might qualify as a trade secret, but you have lots of know-how that is nowhere close to a trade secret. Yeah. So I like companies to be disciplined in their use of the language. If it's a trade secret, if it's confidential information, if it's know-how, then use the right terms. But unfortunately, I do see the terms used interchangeably as if it's one and the same thing. Now, it's an interesting challenge for companies, of course, because if you have employee know-how that is really know-how to do with that business, then the company's got to ask itself, are they comfortable that the information only exists in the employees' heads, or should they capture it and actually make it into a document?
Codify it in some way.
Codify, yeah.
Can I come back to the leak thing? You don't know this, Donal. Gwilym does. I'm a plumber. Of course I'm obsessed with leaks.
I'm a Welshman. I'm obsessed with leaks.
Yeah, spelling's slightly different. I'm a Welshman as well, so well, it should. I'm 79% Welsh, I found out, which we can discuss at some point in the future.
21% is leak.
Scottish a bit. I'm a bit Scottish.
A bit thistle.
Yeah, I'm a bit Scottish. So coming back to I understand it's criminal.
Yep.
I understand my redress, therefore, is through the criminal or similar process. But it's out there. How do I limit damage? Is there anything else I can do to
put the genie back in the bottle?
Yeah.
Well, obviously, if you suspect or you believe that a trade secret's been stolen, ideally, in the ideal world, you should already have in place an action plan. The day you have identified that there's a trade secret theft is not the day you suddenly say, let's have an action plan to figure out what we should do. You already have the plan. Just like you have a fire prevention plan.
The risk management sort of
risk
thing.
management point.
Yeah.
And what's important is what you do in the minutes, hours and days after that incident. In many cases, if it's a digital type of trade secret, you're probably going to have a conversation with your IT guy straight away to do some IT forensics. And you may even want to freeze your network or freeze your computer.
Yeah.
And the second thing you're probably going to have a conversation is with your trade secret litigation guy to say, what do we do now? Do we go for an injunction?
I guess that's what I was thinking about. Yeah, can you injunct?
But it's amazing how many companies don't have a plan. And the problem is, if you only take action 3 years after the incident, that doesn't look good when you go to court. It's like, well, hang on, you've got this really valuable trade secret and you waited all this time. So we are seeing companies, as part of the taking it more seriously, is not just have a policy and have employee education and have access controls and so forth, but also have an action plan. And it's really, who do you talk to when you think that something's happened, who are the people that should be in the loop at that moment in time? Yeah. And what are the immediate actions you take? And it's probably going to be your security guy in the company. Like I said, the IT guy has got a major role to play because of the fact that most trade secrets these days are digital in nature. Yeah. And your legal guy, and it's probably a litigation firm you're talking to say, okay, what do we do? How do we get an injunction to freeze that person's computer when they've left? There's been some odd cases in the US involving trade secrets, and there's even been a case where a company went after the new employer of the person who had left.
Right.
But the person hadn't started yet. So they had like a month's time off between the two jobs. They were convinced that their employee had taken things in his last day of employment. But they went after the new employer. Now, the new employer was saying, the guy hasn't even started yet. You can't accuse us of trade secret. But they were saying, but it's more than likely when he does start, you are going to quiz him.
We are preempting your theft.
Queel timid, isn't it?
And you're thinking like, is that even allowed?
That would be like me wrestling someone to the ground walking past my house because I thought they might steal my bike or something.
Yeah. Although you did have you've had some issues outside your house, so you probably should do that more.
I probably should do that more. Yeah.
Someone drove into a car, didn't they?
Someone did. Yes.
That's all right,
I should probably have a small machine gun tower outside my house. It's probably right.
No, you can't. You're not allowed to do that.
Oh, no.
I've got some. Can I just?
Yeah, no, of course you can, mate.
So, in terms of you mentioned the activity to try and manage the leak management. Out of interest, are the courts alive to the issues of preliminary injunctions and getting in there quickly and kind of supporting that, or how are they doing?
I think the US is far ahead of anywhere else. They're much more on the ball in this. Just an example of how on the ball they are. There's even a division in the FBI and the Department of Justice. So if you're an American company and you've had a trade secret theft, you can go knock on their door and they'll come and help you. They're so helpful, they'll almost take over the case from you. So you've got to think about, do I really want them helping me? Because they may push it in the direction that you don't want it to go. So we are. The central gravity on trade secret trade secret disputes is the US. Although we are seeing more trade secret disputes slowly but surely arise in other parts of the world. But yeah, I knew the ex-guy, the guy who retired. I know him because of my research into trade secrets. I came across this guy. I said, "What do you mean you're ready?" He said, "No, we have a department, and our only remit is to help companies who suffer from a trade secret theft." Yeah. I think it's quite political as well, to be fair.
So one of my jobs in podcasts is to basically stop Lee sticking to his script.
And you do it brilliantly. I don't have a script. I do a little bit of research. I do a little bit of research, which is more than you do, mate. And plan my questions ahead. It's not a script.
We talked about the employee, but actually, what's a large number of cases as well is companies collaborating with each other and then ending up in a dispute. And it's worth highlighting an example of a case. A company called Epic Systems in the US, who make medical record software for hospitals, had a client in Portland, Oregon. And they're a company that probably are lacking in resource. So their whole way of working is when they get a client, they outsource to a third party the actual installation of their software. They hire engineers who will set it up, configure it, train the staff and so forth. So they hired a group of engineers from Tata Consulting, the Indian large multinational. So everybody's happy. Epic had a new client, the hospital had new medical record systems, and Tata got paid for a piece of engineering work. You're thinking, fine, everyone's happy. Except Tata made one mistake. So when they signed the agreement with Epic to do this R&D consulting work for them. Epic said, in order for you to do the installation of our software, we're going to have to share stuff with you. So our trade secrets about how our code is configured, how it's set up, yada, yada, yada. And in the agreement it said, be aware, we're going to entrust you with our trade secrets. Two things you have to do. One is you must only give this information to the engineers working in the hospital. And at the end of the project, you must destroy all the documentation. And Tata didn't. Maybe the project went on for a while. Like typical agreements, they're put in a filing cabinet and nobody looks it up.
Yeah.
So they didn't. The documentation stayed within Tata. Now, Tata is a large company. They're so large that they actually have their own medical record software division called MedMantra, a competitor to Epic Systems. And the documentation, for whatever reason, found its way to some engineers at MedMantra.
Meandered over there.
And Epic found out about it. And they were fined $970 million for trade secret theft.
Well,
now, in the court, they argued, how can it be trade secret theft? You gave it to us. And then they produced the agreement and went, yes, but look at what, they're our trade secrets and trust you with these provisions. They reduced it on appeal, I think, to 420, and I know the law firm representing them, they were celebrating but it's still 420 million for trade secret theft.
yeah.
And we're noticing lots of cases like that. And it's because I think the days of R&D being like locked in a secure area with no one getting in or out, those days are gone. Companies are embracing R&D, subcontracting, collaborative innovation. So your R&D people are out there interacting with others. And often you find either that the trade secret provisions and agreements aren't well crafted, or worse still, they're crafted well, but nobody actually read them to understand what have I agreed to. And we see a lot of cases like that where one company, usually what happens is, it's usually I think between when a smaller company gets into bed with a bigger company, the bigger company seems to have a very short memory. It sort of forgets that it's their trade secret, even though it's in our premises.
Yeah.
It's their trade secret.
Yeah.
And I suspect, I haven't looked at the Ford case with their supplier, but they'd been in bed with this supplier since 1998 up until 2014. Then the bigger company probably said, well, maybe the smaller company hasn't got the economies of scale, doesn't got the resources. They switched to a different supplier, but took information from supplier one and gave it to supplier two. And that's trade secret theft. So I think they're the two. So we see a lot of cases involving employees taking stuff. In fact, there was research in the US a couple of years ago that said 40% of all employees steal stuff on the last few days of employment. Now, some will steal
Normally it's pens.
and paper. Post-it notes. And here are some post-it notes I have from Nokia.
It's not the recipe for Coca-Cola. Or,
no, but unfortunately people will, software engineer thinks I wrote the code, it's my baby, I'll take it. Process descriptions, client lists. So you do see a lot of employee disputes, but you also begin to see a lot of disputes between companies and others in their ecosystem, either key suppliers, key collaboration partners, key clients. And often you look and think, well, how did they get themselves into this mess? And I think it's that either the trade secret provisions weren't well crafted to begin with in the agreement, or worse still, they didn't understand what they had signed. And then later on, that came back to haunt them.
But funny that they're both elements of information management, which is, of course, one of the biggest challenges for any organisation. Yeah. A couple of questions, may I?
Yeah, carry on.
You sure?
Yeah.
You got a bit stroppy before.
No, you drive.
So first of all, on the damages one, you're talking about like pretty vast sums being awarded. Out of interest, is that kind of American-style punitive jury damages, or is this actual damage that was actually suffered?
No, US example.
That's because that's one of the most difficult things.
By the way, the damages the calculation for damages does vary greatly by country. So, for example, there was a case we came across in Brazil a couple of years ago, and it was interesting to see that in Brazil, the damages are based on the cost methodology. So it's how much money did you spend developing your trade secret, how much money did you spend protecting it, that's what we'll award you.
Which is much better especially if you're incompetent, that's fantastic.
But
I can see why that would appeal to you.
No, in US it's to make the other guy behave himself.
Thank you. That's question one. Next one is, this ties in so much to the eternal ex-employee issue. It's impossible to totally control someone who's left you taking stuff that's in their head. This is kind of know-how versus trade secret versus confidential information again. But it sounds like people are using the trade secret thing a bit more to try and stop employees basically doing their job. Is that an aggressive way of putting it?
I mean, one reason I think why the trade secret laws have had so much attention in the US as well is because at the same time there's a movement to weaken non-compete laws. Right. So if you don't have the option of using non-compete, which I think are a little bit crazy in the US, to be honest, I think, I don't mean to be disrespectful, but I mean, having like the cleaner at a school having to sign a non-compete, I'm thinking like, come on. So you do see crazy examples in the US of people having to sign non-compete agreements.
Yeah.
And I think what's now happened as a result of that is that there's a movement to weaken non-compete laws in the US.
It's at odds with any free movement of labour, isn't it? Yeah.
But if you're a company, you're thinking, okay, well, that option now isn't as strong for me. What else do I have on my portfolio? You're thinking, well, I've got trade secret laws.
Yeah. Okay. One more.
And as well, by the way, it's interesting, the US is clearly wanting other countries to make their trade secret laws like the US law. Like, for example, in January 2021, I think it was the Phase 1 trade agreement was signed between China and US to resolve some of their differences due to the trade war. 93 and 94 page document. Chapter 1. Chapter 1 is not about Chinese buying more soybeans from farmers in Georgia. It isn't about the militarization of the China Sea. It's about trade secrets.
Yeah.
Very first chapter in the trade agreement. And it's, I think, one of the reasons why China changed their trade secret laws in 18 and 19. They probably saw this movement. The UK at the moment is doing a research project because it knows that if it signs a trade agreement with the US, the UK will be under tremendous pressure to bring their trade secret laws into alignment with US laws. When US signed the replacement to NAFTA with Canada and Mexico, we saw Canada and Mexico change their trade secret laws.
Yeah.
Why? Because the US attitude is, we want you to have the same trade secret type laws as we have. And US laws are much more severe than anybody else. So you're seeing, like I tell companies, worry about the European directive, but really worry about the US law. Even if you're a European company. That should be your benchmark.
Because it's coming.
Yeah.
Yeah.
And it's because of this extraterritorial reach. So like you're a European company, how might you find yourself in US court? Do you have a US investor? Do you have US suppliers? Do you have US nationals working for you? Do you have any customers in the US? Well, then you've got a US link.
Yeah.
No, there are examples of companies who've used it to their advantage. There was a UK company went after Caterpillar in the US for trade secret theft, a UK company, and successfully won in the US, which I thought was quite brave to go, hang on a second, we're going to go after. So that was an example of, by the way, a previous supplier. They were a supplier to Caterpillar. Sure. Caterpillar then changed suppliers but took some information from them. I think the US is setting the standard when it comes to trade secret laws.
And that politicisation point was something that's come out of quite a few of the comments here. It's the first thing in the agreement with China. And it kind of, I suppose, sums up the fact that, a bit like IP more broadly, it's being recognised more and more and more as one of the greatest assets, and the country that's got the most advanced technology is looking for ways to make sure that it pushes that advantage, not just through being first mover, but also through having the monopolistic aspects afterwards as well.
Yep.
Okay. Yep. That's a comment, not a question. It's pathetic.
No, you're never pathetic.
Thank you.
Don't do yourself down.
I'm glad we're doing this one first, by the way.
Yeah, I know. Yeah. It's would have been quite difficult.
My brains were switched on.
Quite difficult at the end of the day, wouldn't it?
A different point to make, actually, because some of your audience might be more patent people. You often hear the argument, particularly if a company has some new innovation, do we patent it or do we keep it as a trade secret? Actually, one thing I notice as well is that that's the wrong question. It's not patent or trade secret. It should be patent and trade secret.
Gotcha.
How do I use both of them to my advantage? In other words, particularly if it's a more complex invention or whatever, can I take certain aspects of it and patent that? But are there certain aspects that I can keep as a trade secret?
Oh, that's risky, isn't it? Because we have this conversation. So this is actually really live as a patent attorney. Okay. That's a conversation we have all the time with our inventors, saying you kind of got it because it's such a difficult line to check because of the sufficiency requirements.
Yeah, like for example, there's an interesting example. US telecom company, they came up with this robotic system to do automatic reliability testing of mobile devices. And they realized, actually, we want to use both here to our advantage. So they patented a lot of the inventions to do with the sensors and the mechanics and the electronics. But the software code, they kept all as a trade secret. And actually, when they then had an issue later on, they used both to their advantage. Yeah. Now, it works obviously with complex systems where you could actually break it down to say, well, actually, this is, if you have an invention which is narrow, it's very hard to break it down. And then I agree with you, you might run into problems that, hang on, you've got to break patent law here by keeping certain things secret. But I do think that it should be. So I sort of see it. You have a lot of people like to believe in the sort of simplistic options available to you. Do I patent it? Do I keep it trade secret? Do I publish it? Do I do nothing? I think that we're seeing more sophisticated thinking with certain sort of patent committees to say, well, I've got complex options. Yes, I have the simple ones, this, and this. But then, can I patent some of it? Can I keep some of it trade secret? Can I even publish some parts of it? And I think that's interesting thinking that's developed. And I think it's because of the trade secret laws now being quite strong to say, well, how do I use? Because if the damage is going to be caused by one of my own people doing something silly, then patents don't really help me, but the trade secrets do. Or if my supplier does something, I can use trade secret laws. But if my competitor does something, I can use the patent side. So, I do see that coming.
That's one. Because this is so I'm getting a look really quick. But this is interesting because it feeds into that big policy debate about where the patent system sits more broadly, and people see it as as again monopolistic, as potentially risking preventing innovation and spread of disseminating technological advantages. But actually, the fact that we're seeing more and more people thinking patenting's not right here, let's do something else to keep it secret, it's in a sense a policy worry because there's a risk of more things being pushed underground and information never really coming out to be shared.
Yes, I mean that's
not your problem.
That's an interesting issue. Well, the problem is that each form of IP isn't perfect. They all have their own oddities and idiosyncrasies. So you're look at the history. I mean, some of the stuff's been around since the Middle Ages. So you think, well, is it quite fit for purpose? I mean, copyright. I mean, I've become really interested in copyright recently, thinking, okay, but is it fit for purpose and does it do what it should be doing? So I don't really have an answer to your question. I mean, and what you're trying to do is encourage innovation and creativity, and you're trying to have an IP system that supports that and doesn't hinder it. And the downside with trade secrets is you're pushing things to be secret. But then patents are concentrated. I mean, was it 80 companies own a quarter of them and 800 own a half of them? And 85% of them are in 5 jurisdictions. So you think, well, that's not right either. And then you also take, well, if I have a patent dispute involving 4 guys in a garage versus a large multinational, who am I put my money on? I'm going to put my money on the big guy because he'll come up with strategies to just drag it out. So I think the problem we face is that no form of IP is perfect. But greater minds than mine are going to figure out how to solve the problem because every form of IP I look at it, I'm thinking that's not quite right. There's something amiss there. And
I think I can add my that was a clever question on the train moment this morning because believe it or not, I was thinking about the podcast on the train, Donal, and so Gwilym and I have done podcasts in the past about things like the vaccine waiver. I was in a conversation with someone else yesterday. I couldn't for the life of me remember what it was about on the train, but it's what triggered this. Now it's about Crown use in the UK. So if you have a trade secret, with patents, there will be, could we waive this in the public interest? Is there the potential for a trade secret to be attacked, if that's the right word, in the same way? To say, actually, you should be sharing this. The state is going to intervene.
Ooh, that's a damn good question.
Yay! You don't have to answer it. I'll just be happy with my good question.
Well, of course, the problem is because it's a secret, the other party doesn't even know you have it. Now, that said, remember, there are 2 mentions of trade secrets in patent law. I'm going to go a little bit off tangent.
Yeah, you do that. Yeah. But be a politician.
So obviously, you have the requirement that you must keep your invention secret before you draft it or file it. Otherwise, there's a danger that you've created prior act. Patent. So that's the obvious one. But there's also a thing called prior user rights. So that company A comes up with an interesting idea and decides, based on its strategy, IP strategy, we're going to keep this as a secret. So they now have a trade secret that they're using internally, maybe in their factory or whatever. Company B, completely independent, comes up with the same idea later on and decides, based on its IP strategy, to patent it. It gets a patent. Will it get a patent? Yes, because the examiner doesn't even know that you have the trade secret. If later on, if Company B discovers that Company A has a trade secret, what's the situation there? Well, as long as Company A can prove that it had the trade secret in use before the other person filed a patent, it's got prior user rights. So there would be an example of where another party is challenging your trade secret, but as long as you can prove it, and the onus is on company A to prove it, you keep your trade secret, the other person keeps their patent, and company B can go after company C for patent infringement. So there are, maybe not a really clear answer to you, but there are examples where it goes through it. Now, are there examples of others? Well, perhaps here's the creme de la creme of the talk. We're going to talk about tax for a moment. And you may say, why are we talking about tax? The taxman is wising up to the fact that more and more the value of companies is intangible assets. I mean, a lot of people in the IP profession like to talk about this 80-20 rule that back in the 70s, 80% of the value of companies was tangibles, and then about the noughties that had transitioned, and the value of companies these days is intangibles. And the taxman is aware of this because he's thinking, hang on a second, most of my tax rules that have been around for donkey's years are looking more at the tangible assets of companies, and we got to change things. And so in 2014, the OECD updated their definition of intangible assets from a tax perspective. And they included trade secrets. They said trade secrets and know-how are now a form of intangible assets, and we expect you to manage them properly. We do. In particular, what they're trying to do is make sure companies aren't doing tax avoidance and so forth. So the taxman is actually watching this. Now, I'm aware of a number of companies who have been audited by the tax authorities in recent years. And interestingly, where most of the focus of the audit has been is on the trade secrets, not on the patents. Why is that? Because it's much easier for the taxman to figure out what patents you have. It's much harder for them to figure out what trade secrets you have. And in particular, if you're moving trade secrets across, let's say you've got a company that's got R&D in the UK, a factory in France. Well, the obvious question is, you came up with your development in the UK, you've got a factory making that in France, you must have moved trade secrets to France. Otherwise, how would they know what to build and to the parts list or the test spec or whatever? So you moved a valuable trade secret. Did they get compensated? If I move the tangible asset from England to France, I'd expect to see some paperwork. And I'd expect the UK to be compensated by the French. So the taxman is beginning to look at trade secrets because they realise you've got these really valuable assets and you're moving them around, particularly if you're a complex group structure, you're moving them around. Where's the paperwork? Because if you don't have any paperwork, is that tax avoidance? So I think that it's not yet, I don't think the penny has dropped with the IP community yet. It's already, the tax guys are aware of it. I mean, just for example, why did Deloitte build or acquire a major IP consultancy company a couple of years ago? Why are KPMG building an IP advisory team? Because I think they have wised up to the fact that the tax issue is becoming more and more important when it comes to intangibles. I don't think the IP community has woken up to it yet. Not to the same degree. I think they're not thinking like this. Like when they develop it, if you're an in-house guy or you're an IP advisor and you're helping a company with your strategy, how much does tax and tax issues impact your strategy? Probably most companies know. But I think it's going to have to start being considered because the taxman is wising up to this, and mainly driven by the fact that they're recognising that you can do tax avoidance very easily using IP.
It's a neat little squeeze too, because if you want to rely on a trade secret, you have to show value. Mm-hmm. So you can't then go to the taxman and say there's no value. They've got you both ways, haven't they? That's quite neat. Yeah.
And I think clever trade secret litigation guys in the future will go follow the money. They'll say, okay, you're the plaintiff, you're claiming that you've got a really valuable trade secret. Can we see your books? And they go through the books and say, there's no record of this valuable asset anywhere in your financial systems.
So you've got me. Yeah.
I've only got one question left. Can I do my question?
I'm looking forward to it.
Oh, you've got more?
No.
Are you looking forward to it?
I can't ask you one.
So, Gwilym and I have done the podcast on AI as well. We're quite keen on the AI angle, aren't we, mate?
Yeah.
There's two bits to the question, Donal. I'll try and ask it in a sensible way. So the first is, what influence is AI having on trade secrets? Either, this is where the two bits come in terms of using trade secrets to protect the development. So how do you use trade secrets to protect your advances in AI, if you choose to do that? Or, and this might then cut to the sort of work that you're involved in and the stuff that you do, how you use AI to protect your trade secret or monitor it.
If you think of AI as a complex software or digital product, you usually have sort of three parts to the AI machine. You've got the raw data that you pull in to manipulate, then you've got this algorithm and you've got something that comes out. So, AI systems can vary, but my simple thinking is you've got this complex system. Now, parts of the AI machine, you can't think of trade secrets because it's either public information or using public data sources or whatever. But the algorithm, I think a lot of companies are using trade secrets to protect the secret sauce there. Probably driven by the fact that, well, if I go on the patenting route, will I have problems getting the patent because it's software and it's algorithms? Will I have problems defending my patent even if I get it? Will it stay alive?
Is the tech just moving too fast?
And then can I enforce the patent later on? So I think it's again back to this comment about patents and trade secrets. Probably AI machines are the ideal example of where you need to have what here can I patent? And then what can I have as a trade secret? So to answer your first question, I think yes, there are aspects of AI machines that where trade secret protection probably needs to be considered. Then is AI influencing trade secret management? Maybe not AI directly, but if we think about advanced technology, so I'm going to slightly change your question.
Yeah, go for it.
So for example, are we seeing blockchain coming into trade secrets? Absolutely.
I bet you wish you'd asked that.
We've done that too. Why didn't I think of that?
Yeah.
So one area where I think blockchain has an interesting role to play in trade secrets is maybe not those trade secrets that stay inside your company, but the trade secrets that get shared. Having some clear record of that I gave my trade secret to you on the 9th of
token,
March.
it happened then. Yeah.
So I think blockchain has a potential role to play there.
That's a great answer.
Makes sense.
However,
It does tie in very well with
the challenge, of course, is more, it can't be so technically complex that it's a pain in the neck to share my trade secret with you, because you might have a key supplier, you're dealing with them every day, and you want to give them, let's say, a CAD drawing, whatever. So we are aware of companies in the blockchain space who have the technology, and then we're looking for a use case for it, and are examining, okay, is there a use case for it when it comes to the sharing of highly confidential information? So we know a company in the Netherlands that is applying blockchain when you're sharing CAD drawings, particularly if you're like a design house and you're giving it to your supplier, you want to record it, whatever. Or there's a German company as well that's looked at blockchain. So we see blockchain coming into trade secrets, and it probably has a use case. Not for every trade secret. I don't see the value of it yet. Maybe I'm just haven't thought about it enough. If you have a trade secret inside your company and you know this will never go outside the door, does blockchain actually give me anything here? Probably. Why do I want to have a stamp on a certain date and time? Probably not. But the trade secrets that are being shared.
So when there's a transaction.
When there's a transaction.
Yeah.
And I suppose the other thing then is there, if you have a complex group structure and you're moving trade secrets being group members, is there a use there where you would have a record of that transaction? But I mean, intergroup licenses is another. I'm not sure. But I think blockchain rather than AI. Of course, the other possible use for AI is, let's say you've got a really large company, complex activities, and it hasn't looked up until this point at looking to see what information it has that might qualify as a trade secret. Well, you've got two options. Do I do it manually? Do I crawl through my organization and find it?
Yeah.
Or can I apply technology to go basically crawl through my computers, my networks, my SharePoint, my OneDrive to see what information I have in there, what files might possibly qualify. So there might be a use case of that. I mean, you have interesting crawling software. I'm not sure if that's the right terminology, but I call it crawling. It's basically software that goes, digs and looks.
Are they spiders? Is it spiders they call them?
That's the Google thing, isn't it?
Yeah.
Spider, wasn't it? Yeah.
I'm done. That's all my thinking is exhausted.
That has been quite grueling intellectually. Thank you very much. I felt I should have known a lot more of that. But no, that's been really good.
Thank you for sharing all that with us.
Quite nice to sit with somebody who's cleverer than both of us put together.
I know, isn't it? It's
quite painful.
It's not often we are outplayed by our guests.
We're not worthy. No.
I was lucky just to get that back in 2014 to be prompted to go look at this area, because, like I said, before that point, I wouldn't really have thought about what was happening. But we were fortunate that we got sort of a head start, and I suppose working with that in lots of other companies, you see the issues they run into. So, and of course, when the law changes dramatically, it takes a while for that change to permeate through. And I think with trade secrets, we have a lot of companies who are just starting the journey, trying to figure out, okay, well, what do I do in practice, and how do I want to avail of it, but at the same time, I don't want to suddenly strangle my company by making it into Fort Knox that we can't do anything. We still have to run the business. And that's the challenge, I think.
And which is where tools like the ones that you guys are doing come in very useful.
Yeah, that's it.
Yeah, so we have a number of tools. So we have a tool that we developed, which actually got recently approved by a clearinghouse in the US for law tech. So it's basically a trade secret management audit tool. So when we interact with a company for the first time, one of the questions we ask ourselves is, where are they on the trade secret maturity ladder? I mean, can they spell the word trade secret, or are they fairly sophisticated? So obviously, if they can't even spell the word, that then dictates what we do as the next step. So we felt that we needed some way to assess any company in terms of their level of maturity and sophistication. And that's probably proven one of our more successful tools, and we license it to law firms and we license it to operating companies. And it's developed a life of its own in that we thought originally that it only had one use case, which was for us to assess a company. But we have examples. For example, a company took a license and we thought that they were going to use it for self-assessment, but that's not what they use it for. They have incorporated it into their supplier relation management. So they use it to assess another company in their network before they share their trade secrets.
Yeah.
So rather than just saying, because the problem with things like NDAs is like confetti. So just because somebody signs an NDA doesn't mean that they're the right person to share your trade secret with.
Yeah.
So they wanted to have a way of more systematically assessing any of their key suppliers.
Gotcha.
We have an interesting discussion with an IP insurance company about it, because they were thinking, well, we're offering trade secret insurance. Well, the challenge with trade secret insurance is that the insurer is blind. If a company asks for patent insurance, they can get data. They can say, well, what patents do you have? What patents do your competitors have? Are there a lot of patent disputes taking place? They can figure out the risk and adjust the premium. If a company says, I want trade secret insurance, the insurer is thinking, well, what's the risk here? I can't see what your trade secrets are. I can't see whether your trade secrets are being shared widely. But maybe what I need to do is figure out very quickly a sort of filtering scheme that says, can you spell the word trade secret, or are you fairly sophisticated? And then adjust the premium.
Yeah.
So they're quite interested in that tool. And some law firms who've started developing, some IP firms who've started developing trade secret service like it as well, because just like we found, well, when we have a new client, one of the first things we should do is figure out where the hell they are on the maturity ladder.
Yeah.
Then we have cataloging tools, which is the inspiration that came from libraries, because we recognize that companies need to be able to log these assets. We have 2 of those in the market. Why do we have 2? Because not every company is the same. Some companies have a trade secret manager and they like to keep everything in-house. Others like to say, well, we don't have that flexibility. So some like it in the cloud, some don't, some like pull, some like push. So we ended up developing 2 catalog tools because we had certain clients that liked the first one but wouldn't go near the other one. It's interesting, like we had a client in the nuclear research industry, and they looked at our 2 catalogs and said, well, that one we can't touch. Why? Because it's in the cloud. We're thinking, why can't you go near the cloud? He said, you don't understand us. We have nothing in our facility that touches the cloud. We're not allowed to have it. And we're thinking, well, we have another catalog here that's embedded. That's the one we're
That's right, yeah.
We then have another company who's the opposite. It was like their IT guys met us and they said, well, we can't have anything that's embedded. We don't have the technical support. We want it cloud-based. So you have different requirements. And we then have a 4th tool, which is just e-learning, because we realised that a lot of companies weren't educating their employees about trade secrets, but of course, because of COVID, they've embraced e-learning.
Yeah, of course.
And they're thinking, well, we don't have time for the classroom training on this. Do you have an e-learning content? And we said, yeah, we have an e-learning program. So we've ended up with a toolkit just by looking and listening to what clients were hitting us with and say, well, that would be interesting. So
that's been absolutely fantastic talking to you. Thank you so much for coming on the podcast.
Thank you very much.
We normally end with a clever question, but the only question I can think of, that's a bit embarrassing asking it, so I was going to ask you to share me your most top secret.
I've literally written it down here because I knew one of my games is guess what the question is going to be. My secret. I've written it down. Shall I start?
Oh no, that means I've got to think of one then.
Yeah, no, let's do it. My secret is I'm not as tall as I sound.
You're not as tall as you sound.
I'm not as tall as I sound.
I've never thought that you sounded taller than you look. So
you can read into it what you will. That's my secret.
Good God.
I had some really embarrassing ones. God, I knew this was coming.
I do have a good one.
I've got a good one. I have never put a live animal into my fridge. And I don't plan to either, even though you have probably to think about it today. I just have never thought about that. I've never done it, and I don't plan to do it. And I'm thinking, My dog wouldn't fit in the fridge anyway. He's quite big, and he'd probably go ballistic in there. My son's hamster.
We probably should stop that.
Actually, just quickly on that, I was thinking, what did tortoises do before fridges, and why do we still have them? It's amazing. But anyway, go.
Okay, so my birth certificate says that I was born in Portsmouth, and I wasn't. I was born on Barry Island because my mum had gone to sort of visit when she was younger. Met my dad there, who was a Welshman. Went back the next year, and I kind of was born while they were there in December. So she made my dad drive to Portsmouth to register the birth because she didn't want me to be a Welshman. Unfortunately, we moved back by the time I was 2, so I've not got the accent. So my birth certificate is an entire lie. As is my brother's, because my brother's doesn't have his name on it. My brother has an entirely different name because my dad forgot by the time he likes to drink, my dad.
Different era. Yeah.
And by the time he got to register my brother's birth, he had forgotten that he was meant to be registered Anthony, and there was a bloke calling his dog outside, Troy. So my brother was named Troy after the dog. Donal, thank you for coming on the podcast.
Thank you, guys.
That's
Thank
a
you
wrap,
very much.
guys. Thank you.
Thank you.